Section 9, Legal Hotline Q&A, Short Sales Part 1. By the end of the week, Tom and Emily's short sale package had been submitted to the lender. Now came the hardest part, waiting. Mark stopped by Lisa's office. I never realized how much of a short sale involves waiting on someone else's decision. Lisa smiled. That's true. But while we're waiting, let's talk about some of the questions Arizona real estate professionals ask the legal hotline most often. She pulled out several articles she had saved over the years. These aren't just hypothetical situations. These are real questions from Arizona realtors that can help you avoid mistakes in your own transactions. Mark grabbed his notebook. I'm ready. Legal hotline question number 1. Has the seller accepted the short sale simply because the lender approved it? Lisa handed Mark a copy of a lender approval letter. The lender has approved the short sale, she said. The buyer is excited. The buyer's agent assumes the transaction is moving forward. She looked at Mark. Is the seller now obligated to complete the sale? Mark thought for a moment. I would think so. Lisa smiled. Actually, no. She explained that lender approval alone does not automatically create a binding agreement between the seller and buyer under the terms of the Arizona Realtors Short Sale Addendum. The lender has agreed to its terms, Lisa said, but the seller must also agree to those terms. She explained that the seller may review the approval letter and discover conditions that are unacceptable. For example, the lender may require the seller to contribute additional money at closing. The lender may require the seller to sign a promissory note. The lender may shorten the closing timeline beyond what the seller can reasonably meet. If the seller doesn't accept those conditions, Lisa explained, the transaction may not move forward. She reminded Mark that the Arizona Realtors forms include an agreement notice, which informs the buyer that both the seller and the lender have agreed to proceed under the approved short sale terms. Until that notice is delivered, Lisa said, the seller generally has not committed to those lender conditions. Mark nodded. So lender approval is only one step. Exactly. Everyone still has to agree. Legal hotline question number 2. Can a lender require the seller to waive Arizona's anti-deficiency protections? Mark turned the page. I've heard lenders sometimes ask sellers to waive their legal protections. Does that work? Lisa explained that Arizona has anti-deficiency statutes that protect certain homeowners after qualifying foreclosure sales. Over the years, some lenders attempted to include language asking borrowers to waive those protections as part of approving a short sale. She reminded Mark that these legal issues can be complex. The enforceability of those provisions depends on Arizona law, the specific facts of the transaction, and the language contained in the lender's agreement. She looked directly at Mark. This is exactly why real estate professionals should never interpret legal rights for their clients. If questions arise about deficiency liability or lender documents, the seller should immediately consult an Arizona real estate attorney. Our job is to recognize the issue, not answer it. Mark smiled. So when legal questions appear, I know exactly where to send my client. That's protecting the public. Legal hotline question number 3. Is the buyer entitled to see the lender's short sale approval letter? Lisa held up another document. The buyer's agent calls and says, please send me the lender's approval letter. What would you do? Mark thought about it. I guess I'd send it. Lisa shook her head. Not so fast. She explained that the lender's approval letter frequently contains confidential financial information belonging to the seller. It may include loan balances, payoff amounts, financial contribution requirements, personal financial information, other confidential lender conditions. The buyer isn't automatically entitled to receive those documents. She explained that under the Arizona Realtors Short Sale Addendum, the buyer generally receives the seller's agreement notice, confirming that the seller and lender have reached an agreement. If both parties want additional information shared, Lisa explained, they can certainly agree to do so. But never assume confidential lender documents should automatically be distributed. Mark wrote one final note. Protect confidential information. Lisa smiled. That's part of protecting your client. The Legal Hotline is one of the best educational resources available to Arizona real estate professionals. It reminds us that every short sale has unique facts, and the safest answer is often to rely on the contract, stay within the scope of our license, and seek legal guidance whenever necessary. Mark stood and picked up Tom's file. I've learned that sometimes knowing what not to do is just as important as knowing what to do. Lisa laughed. Now you're starting to think like a broker. She smiled. In our next section, we'll continue with more legal hotline questions and look at additional situations Arizona agents commonly encounter during short sale transactions. Key takeaways. Lender approval alone does not necessarily mean the seller has accepted the lender's terms. The Arizona Realtors Agreement Notice communicates when the seller and lender have agreed to proceed under the approved short sale terms. Questions involving anti-deficiency protections should always be referred to qualified legal counsel. Lender approval letters may contain confidential information that should not automatically be shared with the buyer. Arizona real estate professionals protect the public by remaining within the scope of their license and recognizing when legal advice is appropriate. Online discussion question: why doesn't lender approval automatically require the seller to complete the short sale? Answer: because the seller must also agree to the lender's approval terms. If the lender imposes conditions the seller finds unacceptable, the seller may choose not to proceed, subject to the terms of the contract and applicable law. Question 2. Why should a real estate professional avoid interpreting anti-deficiency protections for a client? Answer: anti-deficiency laws involve legal rights that depend on the specific facts and circumstances of each transaction. Licensees should recommend that clients seek advice from qualified legal counsel rather than provide legal opinions. Question 3. Why shouldn't a lender's short sale approval letter automatically be shared with the buyer? Answer: the approval letter may contain confidential financial information belonging to the seller. Agents should respect confidentiality and follow the terms of the contract before sharing lender documents.